Morning to all my dear students. Good morning, Ibrahim, Almas, Ankur, Akshay, Divyan, Chanushka, all of you, Anish, Anil. Good morning, children. Good morning, all of you. Amit, Ansupa, and all the students with us from the portal as well. A very good morning to all of you, children. So today we are meeting for the last class of Indian Partnership Act. We're going to complete the Indian Partnership Act. Good morning, Piyush. So I hope you have revised Unit 1 and Unit 2 very nicely. Today we are going to wind up Indian Partnership Act 1932 by completing the third unit, registration and dissolution of firm. So how are we going to plan this session? First, we will be discussing about the registration, then about the dissolution. And after that, I'll be discussing certain examination question papers also with you. Also, you'll be given a chance to raise your hand, speak up, and ask your doubts if you have any. Good morning, Neil Kothari. So let's proceed ahead. But before going to Unit 3, I wanted to ask certain questions to all of you from Unit 2 itself, because we have completed Unit 2, but certain MCQs were left to be covered. I wanted to do certain MCQs so that आपकी revision भी हो जाएगी and I'll get to know if you have revised it or not. So wear your thinking caps and it's the time to have a quiz. So number one question for all of you is, in what circumstances a partner can retire? Can he retire according to the express agreement? If it is his partnership at will, by giving notice in writing? Do we need the consent of all the other partners or all of the above? What is the correct option for the question number one? Amit, Divyansh, Piyush, absolutely correct answer. Anushka, all of the above is the correct answer. Wonderful. So that means you have revised well. In case of partnership is at will, then you have to give a notice in writing in order to inform the other partners of his intention to retire. Test your knowledge question number 2. A new partner can be admitted in the firm. Do we need the consent of all the partners, a special majority of partners, or maybe a simple majority of partners, or just the new partner's consent is needed? Please tell me the correct answer for question number 2. Excellent. एक बच्चे का भी आंसर गलत नहीं है, सबने सही आंसर दिया है. Divyansh has also mentioned, ma'am, this is section 31. Wonderful. All the partners. So question number 2A is the correct answer. Wonderful, children. Question number 3. Which of the following acts are not included in the implied authority of a partner? Buying and selling of goods on account of partners, borrowing money for the purpose of firm, entering into partnership on behalf of the firm, engaging a lawyer to defend action against the firm. So which of the following is not included in the implied authority of a partner? Absolutely correct. Section 19, where we have studied about the statutory restrictions. A is wrong, Ankur. D is also wrong, Anil and Neil Kothari. C is the correct answer. वो कह रहे implied authority क्या होती है? That partners can do the business. So buying and selling of the goods is your implied authority. You can do that. You can borrow money also, but you cannot open a bank account in your own personal name. You can engage a lawyer who is not allowed to be engaged. An arbitrator, you cannot engage an arbitrator. Submitting a dispute to arbitration, there is a restriction on that. There is a restriction on opening the bank account in your own name, not on borrowing money on behalf of firm. Acquiring and selling of the immovable property on behalf of firm, there is a restriction. And there is a restriction on entering into partnership. So what is not included का मतलब है कि किस चीज के ऊपर implied authority के ऊपर restriction है, कौन सी चीज allowed नहीं है. That is your entering into partnership on behalf of firm. This is not allowed. Is that correct? All of you, C part is the correct answer. Okay. Yes. Anish K, correct. A partner can be expelled if this expulsion is in good faith. Majority of the partners does not agree. Expelled partner is given an opportunity to start a competing business, and where you're paying certain compensation to the expelled partner. Do we need to pay any compensation? No, ma'am. You never told us that any compensation we are paying. Majority does not agree. So that means this is wrong. Majority of the partners should have agreed. Expelled partners should be given an opportunity of being heard, not of starting a competing business. ऐसा तो कुछ भी नहीं था कि हमने बोला कि हम आपको निकाल रहे हैं and अब आप हमारा competitive business शुरू कर सकते हो. Was there something like that? No. So what is the correct answer? Point number A, that is expulsion should be in the good faith. Okay, Amit Wagmire, there was nothing saying that the expelled partner can start the competing business. So that is the wrong answer. C is the wrong answer. A is the correct answer. Vanisha, Anspa, Abdul. All of you have given the correct answer. Sapna Chaudhary, Divyansh, Ibrahim, Neel Kothari, Anushka, Anil, Anish, Piyush, Almas. All of you. Wonderful answers, children. Good. And here is the last question. If a partner commits any fraud in the conduct of the business, then he shall indemnify the firm for any loss caused to the firm. He is not liable to the firm, or he is liable to all the partners, or he is only liable to the third parties. What does we need to do if we have committed any kind of fraud? 10,000 की परचेजेस करनी थी, आपने 15,000 की कर ली, या फिर आपने कोई चीटिंग करी है, आपने पर्सनल प्रॉफिट्स अर्न कर लिए, सीक्रेट प्रॉफिट्स कर लिए, आपने फ्रॉड करा है, तो व्हाट विल यू डू? देन you are required to indemnify the firm. Excellent answers given by all of you. And somebody is writing, ma'am, reference section 10. Divyansh Bhatti has learned all the sections also. So wonderful. So option A is the correct answer. Ibrahim, Anil, Abdul, Divyansh, Anuspav, Amit, Anushka, all of you are correct. A is the correct answer for the fifth question. Okay, we still have certain questions. So are you enjoying these questions? It is helping you to revisiting the chapters. बेटा अगर हम लर्न करते पढ़ते और टेस्ट दे देते ना टीचर को, तो फिर हमारी वैसी तैयारी बहुत स्ट्रांग हो जाती है. दैट मीन्स वी हैव टेस्टेड आवर नॉलेज, वी आर अप्लाइंग आवर नॉलेज नाउ, वी हैव लर्नड इट एंड नाउ वी आर गिविंग अ टेस्ट. सो यू विल नेवर, your energies and the efforts that you have spent on preparing the topics will never go waste. Okay. Good morning, Priyanshi Nagar. Good morning, child. Okay, and Mas and Piyush have answered this one also, but let me read out the question. The partners shall carry on the business for the greatest common advantage, for the welfare of the society. Are we doing partnership for the welfare of society? That is a charitable organization. For advantage of the family members, that is HUF. For earning personal profits, that is ownership, where we just personally we are earning revenues and profits. So what are the partners doing? Partners are doing for the greatest common advantage. A is the correct answer. That is, partnership shall be done for the greatest common advantage. All right. Then seventh, the liability of a minor partner is limited. So A was the correct answer for the previous one. I hope everyone. Greatest common advantage का मतलब होता है, that means for the benefit of all the partners. Liability of a minor partner is limited to the extent of his share in the firm, his personal assets, his share in the firm and personal assets, or he is not liable. Think about question number 7 carefully and answer me. Miss Kaushal, all your answers are correct. Mr. Suraj is also with here in the portal. Jai Shri Krishna, Miss Kaushal, God bless you, beta. Yes, all your answers are correct, absolutely correct. Now question number 7, last question. The liability of the minor is limited to his, he's not liable. Okay. Sapna, that's wrong. To his share in the firm, whatever is his share in the firm, personal assets are not liable. Okay. So the correct answer is the liability of the minor is limited to his share in the firm. Whatever profits I told you, if he has invested 5 lakhs, then only 5 lakhs his share in the firm will be liable to the third parties. His personal assets are never liable because the liability of other partners is unlimited. Okay, but this is not the case of the minor partner. Whenever you have minor as a partner, his liability is limited to the certain extent. You cannot go beyond that certain extent. Wherever the partner's liability is unlimited, that means your personal assets are also liable in order to pay the liabilities to the third parties. Is that clear, everyone? So we have very nicely revised our questions related to excuse me, sir. Students have entered in the waiting room. Somebody at the IT. We need to admit the students. So should I make you the host? Because the request is coming for the students. Ashok sir. All right. Okay, now let's proceed towards the last chapter of Indian partnership, that is registration. Difference between arbitrator and lawyer. Neil Kothari has a question for us. So, what is the difference between arbitrator and lawyer? Arbitrator is a person who is outside the court is settling your case. So wherever we have a fight in partnership, so we can take an action and we can go to district court, high court, supreme court, and we can fight our cases. Like a partner is not paid his share of profits, तो dispute हो जाएगा, लड़ाई होएगी, तो किसी भी उस case में हम we can go and file a case in the court. But arbitrator is a person who is settling your case as an outsider. Yes, a CA can be an arbitrator, Pavan, only if he's Ashok sir, are you there? Technical support. Students are in the waiting room. I have to admit them or somebody is taking care of that. Please kindly tell me. All right. So if you are not directly going to the court and you have different arbitrators who make you sit on a personal basis and they try to settle down your all your disputes. So in partnership, you cannot go to the arbitrator unless you have made an agreement. So you have to make, there is a statutory restriction on going to the arbitrators. All right. All right. All right. I hope I'm audible now, students. Yeah. The topics to be covered in Unit 3 are registration and dissolution of the firm. So registration, we'll be talking about what are the modes of effecting registration. Now, before we move further, first tell me, students, is it compulsory for the partnership firm to get itself registered? Is it compulsory? Do we have to get it registered? Absolutely correct. It is optional for the firm to get itself registered. It is not compulsory to get the firm registered. Why it is not compulsory? Because in the Indian Partnership Act 1932, a choice is given to the firm that you can get your registration done or you can avoid it. But in case of companies, in case of LLP, registration is mandatory. That is why company and LLP are different from partnership, because they have a lot of compliance work is made mandatorily to be done by them. They have to get themselves registered with the ROC, registrar of companies, certification of registration has to be taken. All these things have to be taken care of. Now, but consequences of non-registration. Today we'll be discussing 4 important cases where if you're not registered firm, then you will not get those benefits. Okay, so number 1, we'll be talking about how the registration has to be done. Section 58 and 59 will take care about the registration of firm. If it is optional, but if you're planning to do it, how you have to get the firm registered. Then we'll be discussing the consequences of non-registration. If you're not registered, what will be the effect of the same? So the first half of the chapter, we are going to cover in detail about the registration and consequences of non-registration. Now, children, this is a very, very important topic. September 24 paper also questions have come from this topic. Even in June paper, the examiner has put up many questions from this chapter. So it's a very important chapter. I want each one of you to pay full attention and try to understand. Yes, Abdul, there are consequences which we'll be discussing in detail. Okay. So if you have decided to get the firm registered, you have to file certain documents and application with the registrar of firms. So just say companies, may we have registrar of companies. Here we have registrar of firms. So number one, a statement in the prescribed form has to be filed with the registrar of firms. So this is just section 58 is telling you about the application form. You have to fill up an application giving your firm's name. What is the name of the firm? Let's assume ABC Associates. So you will write down a firm ABC Associates, and where is the place of business? Suppose we are doing business in New Delhi. So that place of business will be mentioned. Complete address have to be given. Name of the exact place where the business is carried out. So in New Delhi, you're doing the business in Rajouri Garden, you will write down New Delhi. The exact business is registered office is at New Delhi. This is not the registered office. This is the place we are doing the business. After registration, it will become the RO. What is the date when the partners have joined the firm? So A joined the firm on 5th August, B joined on 7th September, C joined on 8th October. Whatever are the dates have to be given when the partners joined the firm. But at least two partners should have joined together. Then only you can start a partnership. So A and B, let's assume, have joined on 5th August. C has joined on 8th. Full name and address of all the partners. Mr. A's full name, his address, Mr. B's full name, address, everything has to be given. And the last, you will be giving duration of partnership. If we give the duration of partnership, let's assume I have written that from 5th August, we are going to be partners and this partnership is for 2 years. Then what is this kind of partnership known as? If I am giving a time period, I have written down the duration of the time period, then what is this partnership known as? Is it a particular partnership? Is it a partnership at will? What do you call this partnership in which the time period has been given? Absolutely correct. It is known as fixed partnership. It is known as fixed partnership. Absolutely correct. All of you are correct. And if no time period is given, then what do you call it? Then it is partnership at will. Okay. All right. Good morning, Satyam, and all those who have joined now. It's okay. We have just revised Unit 2 questions, test of knowledge, and now we have started with Unit 3. So it's absolutely fine. You can listen and enjoy the session from now onwards also. You have not missed something major. Okay. Here we have just did the revision of Unit 2. So section 58 statement will be given. Application form needs to be filed. All these contents you should remember because examiner can give you a straight away 4 marks question that how the registration of firm can be done. And in that, you have to explain all these points, how the firm has to be registered. First, section 58, you have to give all the documentations. Then section 59 simply tells you that when the registrar is satisfied that everything of section 58 has been complied with, then you will make an entry in the register, which is kept at the register of firms, and you will file the statement. So I am a firm partner. I will, under section 58, I will take all the documents. I will go to the registrar of firms. And now registrar of firms will make an entry and will record the statement that, okay, fine, Harleen ma'am as a partner has submitted the application of ABC Associates. And once this entry has been made, and that they will see all the documentation has been is in place, they will come and inspect your place of business also, whether you're doing a legal business, all this documentation and other paperwork will be done. And then registrar will issue you a certificate of registration. This is how the certificate of registration looks like. You can just read it like the stamp is there. Then Indian Partnership Act 1932, because this registration certificate is issued under this act. Registration number is given. It is certified that the firm named by Cargo Pack, so name of the firm is given, having its head office at this place and branch office at particular place. So in Thane, Mumbai, it is having its place. Has been duly registered under the Indian Partnership Act. And then in Hindi, the same information has been given. And 24th February 2015 is the date from which the firm has been registered. So the date which is given on the certificate of registration will be the registration date. So when is the registration complete? Number one, section 58 talks about the compliance. What all compliance needs to be done, what all applications needs to be submitted, documents to be given. Number two, section 59 talks about the recording of statement in the register. And number three, we are going to issue the certificate of registration. Firm and company registered means, yeah, they have been certified. Is that clear, everyone? Now, let me take certain points from the study material also so that we don't leave a single point of this topic. Okay, let me just open the study module for all of you. So this is your chapter, children, registration and dissolution. So this is what we're going to do today. Mode of effect of registration and consequences of registration is the topic that we are covering. So let's have a look. Section 58, we have discussed briefly. Registration will be made by sending by post or delivering to the registrar in the area in which the place of business is situated. So every state have their own registrar of firms. Delhi will have their own state of registrar of firms. In Punjab, any city in Punjab, you will have to go to Punjab registrar of firms. So every respective states have their registrar of firms, and you have to go and submit your application by either by post, you can send your application, or you can go and deliver it by hand to that respective place. Yes, Devyansh, you can learn the application of form to be given instead of compliance. That is one and the same thing. So these 6 items you have to learn that these things needs to be submitted in the statement. You can use the word statement or it is an application. Statement का मतलब वही है document कागज जिसमें आपने सारी चीजें ये फाइल करके दे रहे हो. So along with the prescribed fees, so they have not told you the fees, but yes, fees also needs to be paid. Who is going to sign the statement? By all the partners signing the statement should also verify it in the manner prescribed. So all your partners or by the agents, the form application has to be signed also. Now, this is important. A firm's name shall not contain the following words. You cannot have ABC Associates, Emperors, King and Queen Associates, words like Royal, Crown. Have you seen any of these kind of names in any of the partnership form? So you're not allowed to use these kind of names in the names of the partnership form, except where the state government has given his consent. So if there is any government approval that you have taken, you need to take the approval of central government or state government if you want to use, if you want the sanction of such kind of words like king, queen, emperor, imperial, ऐसे words अगर आपको use करने हैं अपने partnership form में, you have to file an application to the state government, and only if they give their order in writing, then only you can be permitted to use such words in your firm's name. Otherwise, generally these words are prohibited. So number 1, application under section 58, application is to be signed by all the partners. And number 3, firm's name shall not include these words. If you want to include these words, whose approval is required? Central government or state government? If you want to include these words, central government or state government, whose approval is required? Come on, children, answer it quickly. State government's approval is required. Good. And UNSPA is not central government, it is state government. Okay, it is written clearly that these are the words which require the approval and patronage of government, except when the state government has given its consent, then you can use it. Section 59 tells you, number 1, you can just mark down points in your study material only, how you have to learn it. The first point is registrar shall be satisfied that all the compliance has been done in 58. Number 2, then he will record an entry in the register. What is that register called? Register of Forms. Number 3, he will then issue the registration certificate. This registration certificate means all the compliance have been done. जो registration certificate है वो proof है कि firm ने सारी compliance करी है. And number 5, recording of the entry in the register of firms is a routine duty of registrar. So if I ask you children that I have recorded, the registrar has made the entry in the register of firms, ABC Associates have submitted their documents. Do you think registration certificate has been issued? The answer is no. Recording of entry is the routine work. Registrar has to do this work. It is the routine nature of work that they have to record this entry. Registration certificate, only once they have made this entry and file the statement, then you will be issued the registration certificate. This certificate will mean that all the application has been submitted. So just by mere doing the entry in the register of firms, the things will not be sufficient. You have to be issued the registration certificate. registration is effected even after a suit has been filed. What is the meaning of suit? Suit means केस फाइल हुआ है. अगर आपके अगेंस्ट किसी ने केस भी फाइल करा है तब भी आप रजिस्ट्रेशन करवा सकते हो, बट यू हैव टू फर्स्ट विड्रॉ द सूट एंड देन फाइल अ फ्रेश रजिस्ट्रेशन. So you have filed a case against someone and you are an unregistered firm. So first withdraw that case and then you get yourself registered. Then you can file a fresh suit. And if you don't comply with the time period given under section 58 subsection 1A, penalty will be charged 100 rupees per day of any bill. So first is section 58, section 59. Third is penalty under 59A1, which says that if the time period is not complied, what is the time period? It is not mentioned. So simply remember the time period which is given under section 58 1A. If you have not complied in that time period, then 100 rupees penalty per year of delay will be charged. Clear, children? 58, 59. I hope it's now absolutely clear to all of you. Now section 69. Specifically, so after 58, 59, 60 to 68 are covered somewhere else. We straight away come to section number 69, which is going to speak about the effects of the non-registration of the firm. Now, ABC Associates get itself registered. Then what benefits they are going to get is these 4 benefits. And if you're not registered, then these are the disadvantages of non-registration. So under 3.2 heading, you can write down, either you can write down this point that these are the points of either benefits that you get when the firm is registered, or you can write down disadvantages of non-registration. Means if you're not registered firm, then what all disadvantages you have to go through. These are the points which are going to be given over here. All right. Miss Kaushal, I hope you're understanding everything. Anybody here has any more doubts? Mr. Suraj and Miss Kaushal, the 2 students over here with us on the portal also. Okay, so under English law, registration is compulsory. So penalty is charged for the non-registration firm. So under English law, the firm has to be registered, but under Indian law, which we are studying, it is not compulsory. It is not mandatory. Indian partnership has not made the registration compulsory, so it does not put any penalty. So if I ask you in the MCQ, do you have to pay any penalty if your firm is not registered? Yes, ma'am, or no, ma'am? Do we charge any penalty if your firm is not registered? No, ma'am. Absolutely correct. But do we have any disadvantages? Disabilities means disadvantages. Yes, we will have disadvantages if we are not registered. So it says registration is not compulsory, but there are certain disabilities of non-registration. Disabilities means disadvantages of not getting yourself registered. If you're not registered firm, then you have to go through these kind of disadvantages. Number 1, no suit in a civil court by firm or other co-partners against the third party. I will take this from my presentation, so you can just refer to the headings. I'm going to explain them one by one. So if you are registered as a law firm, as a partnership, then you can file an action against any other person. But if you're not registered, consequences of non-registration means अगर आपकी firm registered नहीं है, then can you take an action against another firm or another co-partners? Then new suit can be filed by the firm or other co-partners against the third party. You cannot take any action. So if you're not registered firm, you cannot take any action by the firm or other co-partners. No relief is given to the partners for set-off of claim, even if the partners have their own dues applicable to each other. Say, for example, one partner needs to pay 10 rupees to another partner and the other partner has to pay and to the outsiders, and the outsiders have to pay you rupees 8. So you said, okay, 10 rupees, I have to pay 8 rupees, you have to pay. So I'll just set off the claim and I will pay you rupees 2. So this is not allowed. You cannot set off the claims. So setting off the claims is also not allowed if you are not a registered firm. So for example, you said that you made a plan with your friend that, okay, fine, we'll spend equally for while we go to watch a movie. So your friend has spent 500 rupees for the movie tickets and you have spent 200 rupees for the popcorns. So now 300 balance needs to be set it off. So 150, 150, each of you have to bear it. But if you're a partner in a firm, then you cannot make such kind of adjustments. Then you have to pay first full amount which was due to the third party. And if the third party wants to pay you, whatever amount is due as per their timing, they will be paying you. So if partners have to pay to the outsiders 1,000 rupees and the same Mr. C is the third party from whom we have to recover 800 rupees, so partners have to pay 1,000. You cannot say that we'll simply pay 200 rupees only. So setting off is not allowed. Okay. Aggrieved partner cannot bring a legal action against other partner of the firm. Now, who is an aggrieved partner? Aggrieved मतलब जिसको गुस्सा आया, जो केस फाइल करना चाहता है. One partner has said very wrong things to another partner and now he's aggrieved, he's angry and he wants to take up an action against the other partner. But can he take a legal action if the firm is not registered? The answer is no. If your firm is not registered, then you can't file a case against the other partner. So point number 1 tells you that if I'm an unregistered firm, I cannot file a case against the third party. Point number 3 tells you that if I'm an unregistered firm, I cannot even file a case against another party. If I want to do that, I should first get myself registered. Then only I am allowed to file a case against the third party. Then only I am allowed to set off the claims between the partners. Then only I can file a case against the partners also. But point number 4 is a very unique point which says third party can sue the firm. Means whether you are a registered firm, ABC Associates get itself registered or it is not registered, third party can always file a case against you. So listen to a very interesting example. I am a partnership. We are a partnership firm. Me, Suraj, Anish, and Harleen ma'am. Okay, Suraj, Anish, K, and Harleen ma'am. They are 3 partners and they have formed a partnership, ABC Associates. But we did not get ourselves registered. There is a supplier, Mr. Anil, who has not made our payment of 1 lakh rupees. Can Suraj or Anish or Harleen, any of the partners, file a case against Mr. Anil? Tell me yes or no. On the basis of consequences of non-registration, we are not a registered firm. Divyansh is the first one to give the correct answer. Wonderful. No, ma'am. Anushka, Anil, Satyam, Akshit, Shafi, UK. Anish, Piyush, very good. So many students have given the correct answer. No, ma'am, you cannot file a case. Why I cannot file a case? Because I'm not a registered firm. But again, I'm the same firm who is not registered. Now, Mr. Anil had to recover certain sum of money from a firm, that is 50,000 rupees. Can Anil file a case against my firm? I'm not registered firm. Anish K says he can see you. Ansupa, Satyam, Anushka, very good. Excellent children. So if I'm not a registered firm, I cannot file a case against third party. But whether I'm registered or not registered, third party can always file a case against me. So that is why we call it as a disadvantage, because I am not allowed to take a case against you. I'm not allowed to file a case against you if I'm not a registered firm. All right. So let's take up all these points from the study material module also, and there are n number of examples which are given over here. So no suit in a court can be filed by a firm or other co-partners against third party. The firm or any other person cannot file an action against the third party for any breach of contract entered by the firm. So if anyone has breached the contract, firm cannot file a case against them unless the firm is registered. Means unless you are registered or the partners who are suing have been shown in the registrar form. This is a very interesting line. So there are 3 partners, ABC. It's an ABC Associates of firm, and we got a self-registered. Now I am a registered firm, ABC Associates. Can I file a case against third party? Yes or no? Jaldi jaldi batao. Now I am a registered firm. Can I file a case against the third party? Absolutely correct. Everyone says yes, ma'am. Now you can file. And whose name has been entered in the register of firms? A's, B, and C. Now D has joined as a new partner, and his name is not there in the registration of the firms. Can D also file a case against the third party? Can D also file a case against the third party? Why no, ma'am? Absolutely correct. Those who said no, ma'am, that's correct answer. Because the line says partners who are suing, जो लोग case कर रहे हैं, their name should have been entered in the register of firms as partners. So if your name is not entered in the register of firms, means you are not required, you cannot file a case against the third party. I hope everyone is clear on this point because we have a very interesting case study which we'll be doing related to this specific topic also. No relief to the partners for set-off of claim. So it says if the partners have any claim against each other, neither the firm nor the partners can claim any relief, but up till rupees 100 it is allowed. Anything over and above 100 rupees is not allowed. So it says the rights of the partners to sue for dissolution, where it is given. Yes. So the right to sue or claim a set off if does not exceed rupees 100 in value. So up till rupees 100, you can do the setting off of claim. I had to pay you 70 rupees. You have to give me 80 rupees. How will we do the settlement? You pay me 10 rupees. Everything is sorted. But anything over and above 100 rupees, you are not allowed to set off if you are not a registered firm. Aggrieved partner cannot file an action against the other partner. So partners cannot file an action means they cannot file a case against each other, but they can sue for the dissolution of the firm and realization of the share. So there is an exception which is given. Number one exception says third parties to sue the firm or any of the non-registration will not affect the following rights. Third party can always take an action against you. So this is a fourth point that yes, third party, even in case of unregistered, third party can file an action. So this is an exception, means non-registration is not going to affect this third party's right. All right, ma'am. Right of the partners to file a case for dissolution of firm or settlement of the accounts. That you can do. So there is a partner, Mr. A, who is very angry with Mr. B and he wants to file a case against Mr. B. If you're not registered firm, he cannot file that case. But Mr. A is very angry and he wants to file a case. He's not happy with which the firm is functioning and they want to dissolve the firm. He wants his settlement of his accounts. He wants his payment shall be given. Then even if it is an unregistered firm, he can file a case for the dissolution of the firm, या फिर अपनी पैसे की settlement के लिए settlement of the accounts of dissolved firm, या फिर dissolved firm की realization of property के लिए, means I have given you table furniture, I want to realize my property, please pay my property back. So for these dissolution cases, partners can file a case, but otherwise they cannot file a case while they are partners. Okay, you cannot bring a legal action against the firm or other partner if you're not registered firm, but for dissolution of the firm, realization of his share, he can file a case. And the third point is power of an official assignee or receiver to release the property of insolvent partner. So insolvent partner is also not affected by the registration of the firm. If you have become insolvent, what is the meaning of insolvent? Means your liabilities are more and your assets to pay off the liabilities are less. So who is appointed for the insolvent partner? An official receiver, an official assignee by the court is appointed. He will sell off the property and assets of the insolvent partner in order to pay off the liabilities. So can he take an action? Can he take his property into custody and file a case? So it says official assignees and official receiver is not affected with the registration and non-registration of the firm. Is that clear, children? Is everyone clear about the exceptions? Non-registration will not affect the following rights, and these are the disadvantages that we get if you are not a registered firm. Right to suit and proceeding by the legal representative. Even the legal representative's partners, so one of the partner has died, his legal representative wants to take an action against the firm for realizing his property. ABC Associates is an unregistered firm. Mr. A died. Now A's son, Mr. D, wants to file an action against ABC Associates. It's an unregistered firm. Can the legal representative file an action against the firm for the settlement of the accounts of Mr. A or for realizing the property of Mr. A? Tell me, children. Anushka says yes, ma'am. Divyansh says no. Vanisha says yes. Can the legal representative of unregistered firm, if you're not a registered firm, can they take an action? Very good. Ansupa says no, ma'am. Prapreet says no. Satyam says no. See, I tried to confuse them and they all got confused. Very nice. Piyush, correct answer. Even if you're not a registered firm, then also legal representative action ले सकता है. ऑफिशियल असाइनी एक्शन ले सकता है, थर्ड पार्टी एक्शन ले सकता है. दिव्यांश इज आस्किंग द फर्स्ट पॉइंट. फर्स्ट पॉइंट सिंपली टेल्स यू दैट थर्ड पार्टी कैन फाइल अ केस whether you are a registered firm, whether you, so we did the example, Anish, Suraj and Harleen ma'am, they were unregistered firm. Anil did not get his money. Anil could still file a case against us, even if we are not registered firm. Legal representative, one of the partners dies, the legal representative want to take an action, they can take an action. One of the partners declared insolvent, official receiver wants to take an action, they can take an action. Up till rupees 100, you want to set up the claims, you can set up the claims. All right. Everyone have understood? Any doubts still here, children? Anyone has any doubts? Okay. Suraj and Miss Kaushal have also written that ma'am understood correctly, so that's great. All right. What is persuasive pressure? Divyansh, persuasive pressure means that somebody who is put into regular pressurizing. So it says disabilities have a persuasive pressure for the registration, means now since you have not got your firm registered, then you get a regular pressure for the registration. Okay, then you get a regular uh, pressure for the registration, means you have to get your firm either you have to get your firm registered, or there will be a regular pressure, means that now if I want to take an action against the third party, I cannot take an action because my firm is not registered. Okay, have you understood? So persuasive means in continuation, regular pressures on the firm. Otherwise, if I'm a registered firm, then there won't be any pressure. If I'm not satisfied with the third party, I can take an action against them. Okay. Ma'am, can you please explain the point of no relief to partners? Okay, Anil, I will explain you. Vanisha is saying, ma'am, legal representatives can sue the partners also, ma'am, if firm is not registered, or they can sue. Legal representative can sue the partners if the firm is not registered. Okay, Vanisha. So the legal representative wala case means that even if the partners, it is a not registered firm. Okay, we have not got a self-registered. Now, one of the partners died. Who is his legal representative? Their son or their child who wants to recover the money. So they can file an action, whether the firm goes in. So death of the partner, I explained you, whether you dissolve or you don't dissolve the firm, that is up to your choice. But that might not affect the existence of the firm, also the retirement and death of a partner. So, but still, even if you're not registered, legal representative can take an action against you. All right. Okay, Satyam, you want to speak something?
हेलो.
Yes, beta.
गुड मॉर्निंग मैम.
Good morning.
मैम, मेरा क्वेश्चन ये था कि जैसे अगर कोई फर्म नॉन रजिस्टर्ड है और उसको थर्ड पार्टी को सू करना है, बट वो नॉन रजिस्टर्ड है तो वो सू नहीं कर सकता, तो क्या वो पहले रजिस्टर होके बाद में उसको सू कर सकता है?
अच्छा, थर्ड पार्टी के अगेंस्ट व्हेन यू नॉट टेक, अच्छा आप नहीं एक्शन ले सकते हो, बट यस इफ यू वांट टू फाइल एन एक्शन देन यू विल हैव टू गेट अ फ्रेश रजिस्ट्रेशन, देन यस यू कैन टेक एन एक्शन, provided Satyam, all the partners who are taking an action, their name should have been entered in the register of firms.
मैम
Sometimes
बट
what happen is one of the
मैम बट
partners.
थर्ड पार्टी ऐसा नहीं बोल सकती कि ये लोग नॉन रजिस्टर्ड थे, बाद में रजिस्टर्ड होके क्या नाम एक्शन ले रहे
So
हैं, ऐसा
नहीं,
कुछ?
that is not third party's headache. That is our headache as a firm. If we want to take an action, then it becomes a very tedious process. ना now मुझे केस फाइल करने, अब मैं पहले रजिस्ट्रेशन ऑफिस जाऊंगी रजिस्टर कराने के लिए. So it is better, it is safer for us to get a self registered on time. Although it
ओके,
is an
थैंक यू
option,
मैम.
but since we have this disadvantage, then you should get yourself registered.
ओके, थैंक यू मैम.
Okay. Shefi UK is asking, is it possible to run the business? Yes, definitely you can run the business even if you are not registered firm, because registration is not compulsory. Okay. All right. Vanisha has also written understood. So that's great. Satyam has also understood his point. Divyansh, I hope your point is now clarified. Anil has a query. Relief to partners. So relief to partners means that you don't, relief means किसी को relief दे देना, that means relaxation दे देना कि now I can set off of my claims. Setting off of claims, Anil, means that you can do the knocking off the entries. Like मुझे Anil आपको 10 rupees देने हैं and you have to give me 8 rupees. So what is better? I give you 2 rupees, na? Setting off हो जाएगा claims का. But this setting off of claims is not allowed if you're not a registered firm. Is that clear? Devyansh, you don't have to learn sections first of all. So section 59A1, is it important or not important? We cannot comment on that because every line written on the study material is important. What I told you that it is written that if you have not filed as per the time limit given under 58A1. So what is that time limit? You don't have to search for that. As it is, you can remember. All right. Clear, everyone? All right. Okay, children, so let's take a small break over here and then you just give reading to these 2, 3 pages. I'm going to do a case study of registration and then we'll be starting with the dissolution of form. Let's take a small break here. Welcome back, students. So now let's move towards the case study that we are going to discuss. Somebody has written a doubt. Divyansh, you want to ask something? Yes, beta, this penalty of 100 rupees will be applicable. Okay? Yes, Divyansh, you can speak.
मैम वो जो 100 रुपीज का उन्होंने तो बोला कि रजिस्ट्रेशन कंपलसरी नहीं है पहले इंडियन पार्टनरशिप एक्ट 1932 के हिसाब से, तो आपको पेनल्टी नहीं देनी पड़ेगी। सेक्शन 69 आप जब पढ़ रहे थे कॉन्सिक्वेंस उसकी लाइन में आया था, और ये 59 ये सेक्शन में पूरा पेनल्टी देनी पड़ेगी 100 रुपीज। तो समझ में नहीं आ रहा देनी है कि नहीं इसमें।
Okay, I'll tell you. So now you have decided to get your firm registered. So when you have decided to get your firm registered, a compliance has to be made as per section 58. You have to give all the documents and other things have to be done. But now you are getting your firm registered, compliance is being done. If you make any default in giving your paperwork, जो चीजें आपने देना था, डॉक्यूमेंट्स देने थे, जिस टाइम पीरियड में सबमिट करना था, वो आप नहीं करते हो तो आपके ऊपर पेनल्टी चार्ज हुई. So penalty of 59A1 is related to 58 and 59. Are you understanding, children? It is not compulsory to get yourself registered. No penalty will be charged if you don't get yourself registered. But if you are into the registration process, then there are certain rules that needs to be complied with. If you don't follow them, then penalty will be charged on you. Is that
Okay, ma'am,
clear to
understood.
everyone? Okay. I hope your point is also clear. Another child has also raised a doubt. What's his name? Divyansh is clear. Anish, I hope now you're clear. Yes, it will be calculated on the basis of number of years. Okay, Anish? These all exceptions, 0.5, we have read, we have discussed. Now let's do this example number 1. A and Company is registered as a partnership firm in 2017 with the partners A, B, and C as partners. You will not read the answers. You will just read example number 1 and you will answer me back without cheating from your books, children. 2018, it is a registered firm. In 2019, B and C file an action against X on behalf of A and Company without taking a fresh registration. Now, the first question for consideration is whether the suit is maintainable. So there are 3 partners, A, B, and C. One of them has died. Now, only 2 partners are left, B and C. Can we take an action against X? X is a third party. Can we take an action? Everyone says yes, ma'am. Why? Because B and C are already in the register of firms, because the firm is registered. Absolutely correct. Wonderful answers given by all of you. But children, if I ask you, one another partner, Mr. D, has been admitted into this partnership firm, then can A has already died. Can B, C, and D file a case against X? If B, C, and has taken a new partner, then can they file without the fresh registration? No is the correct answer. Absolutely correct, because the name of the partners who are suing shall be shown in the register of members. So here name of B and C was in the register. That's why the case is maintainable. Here the name of the new partner has not been entered. Therefore, the second requirement is not met. Hence, the first fresh registration has to be taken. All the partners who are suing this name shall be in the register of members. Then only you can take a action against the third party. All right, I hope everyone has understood now registration of firm. It is completely done. Examiner has asked you question related to what are the consequences of non-registration. या फिर इस तरह की case study can come in the exam and they can give you questions. Beautifully, ICAI module has explained how you have to write the answers. So study it, learn it, and try to write also in the same way. Now we're going to do section 39 to 47. Roughly 8 to 10 sections are left in this chapter. And quickly we're going to finish this chapter today. That is dissolution of firm. So important part, registration of firm is complete. Now we are moving to the second topic of the day. That is dissolution. So dissolution means discontinuance of the legal relationship existing between the partners of the firm. One is dissolution of partnership, another is dissolution of the firm. So if I'm just changing the partners, A, B, C are three partners, D is admitted, or A, B, C, D, E are the partners, E is retiring, then only my constitution of the firm is getting changed. Then I'm not dissolving the firm, I'm dissolving the partnership. Dissolution of partnership will not lead to discontinuation of the business. I am still continuing my business, new partners are joining. The change in the constitution of the firm is happening. So dissolution of partnership is only dissolution of reconstitution of the firm. So it says one is, this test your knowledge we are going to do later on. First we'll finish the syllabus. So discontinuance of partnership between all the partners is dissolution of the firm. Means now the grudges have come between the partners. Can you see how the wall has broken? Everybody is pinpointing, they're fighting with each other. Now they cannot continue as partners anymore. So then whole of the firm has to be dissolved. Dissolve karna means binding up karna, finish kar dena, business ko close kar dena, end kar dena. That is known as dissolution of firm, where whole of the firm is ending its business. But dissolution of partnership means only you are changing the partners in between the firm. The partners are coming, partners are going. So there is important differences between dissolution of partnership versus dissolution of firm. Dissolution of firm means discontinuance of firm with partners between the partners of the firm. All the partners have discontinued. Now there is no relationship between the partners. They're going to dissolve it. They're going to end it. Is that clear, everyone? Now let's move ahead towards the differences between the partners and dissolution of firm versus dissolution of partnership. So dissolution of firm, children, means discontinuance of the business. You have winded up the business, you have closed the business. There are three partners, A, B, and C. If relation between all the partner has ended, then the firm gets dissolved. But if D has joined as a partner, then it is a dissolution of partnership or dissolution of firm. Tell me. If new partner is joining, one partner is retiring, then what is it? Dissolution of firm or dissolution of partnership? Yes, answer me, children. Absolutely correct. Pavan Kumar, wonderful answer. Piyush, Devyansh, Anil, everyone has given the correct answer. Then it is only dissolution of partnership. It is not dissolution of firm. Dissolution of firm involves winding up of the business. Means you're selling off your asset. Realization ka matlab hota hai sell your assets and pay off your liabilities. Now I'm closing my business, so I'm going to sell off all my assets and pay off all the liabilities. Mr. Akshit, can you now see our queries? You can raise your queries here also, beta, don't worry. Yes, Mr. Suraj, that was dissolution of partnership. Absolutely correct. Okay. So now when you're dissolving the partnership, you are reconstituting. There you do revaluation of assets. So you remember your accounts, books of account, when you were doing in accounts chapter, dissolution of partnership, revaluation of assets, assets ka revaluation hota hai, liabilities ka revaluation kara jata hai, means on that date, what is the value of your assets and liabilities when the partnership is dissolved. But in dissolution of firm, you're closing the business, you sell off your assets and you pay off your liabilities. Realization account is made in dissolution of firm, revaluation account is made in dissolution of partnership. Firm may be dissolved by the order of the court. Today we are going to discuss section 44, the most important section of Indian partnership, where the court is going to order that dissolve the firm. You're always fighting, you're having disabilities, you're having problems in your firm. Why don't you just end the firm? So court is going to order the dissolution of firm. But partnership is not ordered by the court. Court will not tell that the partnership shall be dissolved. Court can only give the order for the dissolution of firm. Dissolution of firm involves dissolution of partnership. Obviously, the partnership is also ending, but this may or may not involve the dissolution of firm. In which you are having closure of books of accounts. Tell me true and false. Dissolution of partnership, complete closure of books of accounts is done. Yes or no? In dissolution of partnership, complete closure of books of accounts is done? No, ma'am. Absolutely correct. And dissolution of firm, the complete closure is done. Dissolution of partnership does not involve the final closure. The books still continue. We are just changing the constitution of the firm. Everyone is clear about that. Now, section 39 we have done. Now we're going to do section 40 to 44. Section 40 to 43 tells us about the cases. Now we're going to discuss the modes of dissolution. Dissolution of firm hota kaise hai? Which, by what methods? Okay? By what methods we're going to dissolve the firm? Number one, without the order of court. Where court is not interfering, section 40, 41, 42, 43 tells you the cases where you yourself, you're dissolving the firm. Partners have decided to dissolve the firm. But section 44 specifically talks about the dissolution by the order of court. Now, 7 marks question has come in the exam recently in September paper also. What are the cases where the court can order the dissolution of firm? So when you get such creamy, straightforward questions, you simply have to learn them, you have to write them, and you get 6 out of 7 maximum marks, provided you have written everything correct. So dissolution of firm happens without the order of court and by the order of court also. First 4 are the cases where we don't need to order the court. Section 40, by an agreement. Partnership is formed by an agreement. It also comes to an end by an agreement. Section 41 is compulsory dissolution, means something has happened due to which the firm has to be dissolved. There is no choice in that. Then it is contingent dissolution. What are the cases, emergency cases, situations by law you have to dissolve the firm? Then it is dissolution by notice and dissolution by court. So let us see number section 40, where it talks about dissolution by agreement. So we have understood, children, partnership is formed by an agreement. A, B, and C decided to dissolve the partnership. Consent of all the partners is given according to the contract between partners. The partnership will come to an end. So if A, B, C, D are 4 partners and only 2 partners give the consent for dissolution, can the dissolution happen as per section 40? Absolutely correct. I think Pavan Kumar, you also get your answer. No, it cannot happen because consent of all the partners is required. Vanisha, Deansh, Anil, Amit, everyone is correct. All the partners have to give the consent, then only the partnership will get dissolved. Dissolution can also be inferred from the circumstances like closure of the business or final accounts. So if you're closing the business, your final accounts are getting to an end, everything will happen depending upon the contract that you have made between the partners. Section 40 is very simple. Unanimous consent is required, final closure happens, and all the books are closed if all the partners have agreed. Now, section 41 tells you about the compulsory dissolution. Something has happened which has made forcefully for us to that dissolve the partnership. Happening of an event. Our business has now become unlawful. Suppose you're into a business of trading of a particular chemical that you put in the medicines, and law has banned that chemical, that now you cannot trade in this particular chemical. Then the business has become unlawful, so the firm has to be compulsorily dissolved. Now, these partners who are into this particular chemical, they have to dissolve the firm, although they can do some other business, but this business they will have to wind up. They will have to dissolve the firm for this particular business. Just a second, children. Yes. So section 41 is clear to everyone. Section 41 speaks about the compulsory dissolution, means something has happened due to which the business has become unlawful. Now it is no longer possible to do the business. But Section 42 tells you certain contingencies, means certain cases, emergency has occurred because of which we are dissolving the partnership. So there is a thin line of difference between 41 and 42. 41 में compulsory dissolution ऐसा हो गया है कि अब impossible to do the contract हो गया, so you have to dissolve the firm. But in section 42, we are going to study 4 cases when the partnership gets dissolved. Number 1, when the term has expired. What do you understand by this word? When the term has expired means it was a fixed partnership for 5 years. 5 years expired, partnership comes to an end. Number 2, when the partnership was for a particular adventure or a venture, that venture has now completed. That is a particular partnership. Once the particular partnership ends, it gets dissolved. By a death of a partner, the partners have died. I hope you all can hear me, children. Divyansh, is it audible now? Okay. If the partners have died, then also the partnership comes to an end. Unless contrary contract, means if you have not agreed, then it will be getting dissolved, but you can make a contract that death or retirement will not affect the dissolution. So if you have decided something else, then we will go as per your decision. Otherwise, death of a partner will also lead to dissolution. Or the partner has become insolvent. Whenever the partner has become insolvent, then also the firm gets dissolved. Is that clear, all of you? So what are the 4 cases? Fixed partnership, particular partnership, death of a partner, insolvency of the partner. Section 42 सिर्फ इन contingencies की बात करती है. Okay. Thank you, Satyajit, for confirming it's audible now. That's great. Okay. So section 41, 40, 41, 42, everyone is clear. Now let's talk about section 43. So ma'am, we have spoken about partnership, which is a fixed partnership, particular partnership. What about partnership at will? That we have already discussed. Section 43, partnership at will. A partner communicate his intention in writing to another partner that we want to get the firm dissolved. Then that firm gets dissolved. What is the effective date of dissolution? The date which is mentioned in the notice. So A, B, C, 3 partners and they're doing partnership at will. क्या होती है partnership at will? Where no time is decided, no duration of partnership has been fixed. Now A, B, and C, Mr. A said that I want to dissolve this partnership. I don't want to continue. So he will write a notice in writing that by 5th August, this partnership should be dissolved. Then when does your partnership comes to dissolution? By 5th August. So what is the date mentioned in the notice will be the date of dissolution. And suppose he has given this notice on 1st August and no date was given in the notice. Then what will be the effective date of communication? What will be the date of dissolution? If the notice was given on 1st August and no date was given in the notice, what will be the effective date of dissolution? 1st August. Very good, Vanisha. Absolutely correct. Anushka, all of you. 1st August will be the date of dissolution. And if date is given, then that date from which the notice has been given mentioning the date will be considered as the date of dissolution. I hope everyone is clear. Abdul, Ansupa, all of you have given the correct answer. Miss Kaushal, Sahil, Shraddha, all of you have given the correct answers over here also. Wonderful. Mr. Suraj, Natasha. Okay, we have Natasha also. Good, Natasha. Okay. So section 40 to 43, any doubts, children? Anyone wants to ask anything, any point from the study material you have not understood, any point from the examples you have not understood, anything you want to ask? Please feel free to ask. No doubts? Wonderful. Then section 44. What does section 44 tells you? Section 44 talks about cases. There are 8 cases in which the firm is dissolved by the court's order. So 44 A, B, C, D, E, F, G, H. 7 such cases on which the dissolution happens by the court's order. So these are the 6, 7 cases when the court will order the dissolution. Now, one by one, we are going to do all these cases when the partner becomes unsound mind. What happened when the partners become unsound mind? So there are three partners, A, B, and C. And one of the partner has now become of unsound mind, means he was doing the business very normally, but now he is not able to do the business with you. He has become of unsound mind. He has gone mad. Can you do business with a person who is not in his senses, who is an insane person, who is mad by his mind? Can you do business with such a person? Tell me. Can you do business? Can an unsound mind person able to enter into a contract? No, ma'am. So now what will happen? The other partners will go and file a case in the court that we want the firm to be dissolved, and court will send the order of dissolution that under 44 subsection A, firm shall be dissolved because the partner have become of unsound mind. Is that clear? The second is the case of permanent incapacity. Something has happened because of which the one of the partner is completely paralyzed. He cannot move. He cannot work. He has gone into coma or into subconscious mind. Physical health problem has happened. Now he cannot work. Then also the court will order the dissolution of the firm. But if that partner has just fallen ill, he's just having a regular backache or a headache, then will you call it the case of permanent incapacity? Yes, ma'am, or no, ma'am? Then will you call the case of permanent? Absolutely correct. No, ma'am, that will not be the permanent incapacity. Pavan Kumar KS is asking, what is the meaning of the term partner suing? Partner suing means जो partner case file कर रहे हैं. Partners other than the partner suing means जो partners sue कर रहे हैं, मतलब case file कर रहे हैं. Then the partner other than the partner suing means one who is filing a case. Okay, Pavan, I hope it's clear. So the first point talks about the mental disability, unsound mind. Mind नहीं चल रहा बंदे का. Second point talks about permanent incapacity, means physical disability. Person is not able to move, walk, cannot do anything. Then the court will order the dissolution of firm. Point number 3 is guilty of conduct which affects the carrying of the business. 44C. One of the partner is always taking wrong decisions, is always doing misconduct in the business. He doesn't know how to speak with the clients. He's always shouting, yelling. आप मुझे खुद बताओ, आपका कोई ऐसा दोस्त है जिसको हर वक्त गुस्सा आता है, क्या आप उससे बात करोगे? जो अच्छे तरीके से बात नहीं कर रहा, who is very rude, who is always angry, do you like to talk to him? So how can you do business with such a person? You cannot do business with such a partner who is guilty of misconduct. So the partner other than this partner will file a case where it is written, I'll show you in the study material why you're getting confused about this point. No, ma'am, we will not do business with such person. Very good. Excellent answers. Nobody wants to do business with that. That means we should learn these good habits. We should always be polite because nobody will try to do business also with us if we're always shouting, yelling, and misbehaving. Okay? Dissolution by the court's order, section 40, we have done. Contract between the partners means contract that they have already made, means the partnership agreement. These are the cases where the firm is dissolved. 4 cases, specific cases, notice by partnership at will. Now we are doing these cases. So A has severe infection and got typhoid. This is not the ground of dissolution. It does not mean that the business will come to it. So misconduct means where a partner other than the partner suing, means the partner which who are filing a case, not that partner, the other partner. So A, B, C are 3 partners. So A is guilty of misconduct. Other than the partner A means B and C are filing the case, which is likely to prejudicially affect the carrying of the business, means it is affecting my business. If you're not speaking nicely with the client, I will lose business. They will not come to my shop. They will not buy products from us. So that misconduct should be related to the conduct of business. Adverse effect should be on the misconduct on the business. Each case of nature will be decided whether it is a misconduct or not. Now, let's look into another example. A, B, and C are 3 partners. You all said, ma'am, if A is always shouting, yelling, nobody will do business with him. Misconduct, you will file a case with the court. Court will order the dissolution. But if, on the contrary, Mr. A is a very good human being, he talks very politely with the customers. B and C are also very nice. But in personal life, Mr. A is a very bad man. He's always fighting with his children and his wife at home. Will that be the reason of misconduct? Is it affecting my business? Law says adverse effect on the misconduct on the business have to be seen. If the nature of the human being at home is something else, although you will not personally like it, such a person, but that is not affecting your business. So that cannot be the ground of dissolution. All right. Yes, Pawan Kumar, it doesn't matter for the business. That's wonderful. So examiner can give you these kind of questions that misconduct. तो फटाफट से 44C नहीं apply कर देना कि misconduct लिखा है तो that means dissolution by the order. You have to understand misconduct, whether it is in the nature of business or not. Now, persistent breach of agreement. Persistent means continuous. Please write down the meaning. Persistent means continuance. Breach means धोखा देना, breach करना. Agreements को तोड़ना. Now, one of the partner, Mr. A, is always breaching the agreements. There was a rent to be paid on 5th of every month. He's paying rent on 12th of every month. There were certain agreements to be filed within 1 month of the case. Agreements need to be filed. He's not doing it on that time. Continuously, he's breaching the agreements. He's keeping erroneous accounts. Erroneous accounts means galtiyan hai uske accounts mein. He's holding cash more than the allowed. You're allowed to hold 50,000. He's always keeping 1 lakh in hand. Refusal to show the accounts because of the repeated request. Everybody is saying, please show us the accounts. You're not showing it. Embezzlement of cash means cash के साथ हेर-फेर करना. पैसे इधर-उधर कर देना, embezzle कर देना. So these are the 4 cases where the court can order the dissolution on the breach of contract. Means whatever contract you have entered between the partners, now you're not following it. You're continuously breaching the contract. एक बार ब्रीच कर दिया, 2 बार कर दिया, continuously persistent breach of agreement. 1-2 बार तो चलो गलती से अगर आपसे हो गया, there is a mistake chance also. So that will not be the dissolution by court, but persistent is the word that you have to write in the exam if you want to dissolve the firm with this court's order. So example number 4 says if one of the partners is keeping erroneous accounts and omits to enter receipts, or there is a continuous quarrel between the partners, हर वक्त लड़ते जा रहे हैं. There is a state of things that destroys the mutual confidence. See, children, partnership is all based upon confidence and trust. If you break my trust, why will I do business with you? One of the partners has received rupees 1 crore from the client and he has put it in his pocket. I will immediately go and file a case against him. How can I say this is a galti se mistake? I have kept 1 crore in my pocket and I forgot to bring it to the business. Can you do such mistakes? Obviously, it's an intentional mistake. Okay, so your confidence is, you will not have confidence on that child. You cannot, not on the child, on that partner. You cannot have trust on that partner. So the court will order the dissolution of the firm. Okay, everyone is clear about persistent breach of agreement? Now let's move to the transfer of interest. So section 29, we have read that we can transfer our interest to another partner. Sub-partnership is created, that is fine. But here, if one of the partner has transferred his whole of his interest to a third party, 1/3 share था मेरा, 1/3 में 10%, 20% दे दिया, सब partnership create कर, it's okay. But whole of the 1/3 I'm transferring to third party. Or he has allowed his share to be charged or taken by the court in recovery of land areas due by the partner. Then this is not allowed. Firm will be dissolved by the order of court. So there was certain amount of taxations or land revenue being paid to be paid to the government. And the partner said, okay, instead of paying you the revenue or the taxes, I will give you my share of profits. So if you're doing this kind of agreements, arrangements with the government, you are evading the taxes, you're transferring your interest just to pay off the liabilities of the government, then court will order the dissolution of the firm. All right, now continuous and perpetual losses. It is such a small line, 2-liner written over here, and 4 marks question come in the exam where the examiner tells you that there is a firm ABC Associates. They have been sharing the profits equally, but the firm is not into profit. The firm is into losses from last 5 years. What will you do? What will your consultancy give them? The consultancy as per the decision of the chartered accountants, what will you say? So you will say where the business of the firm cannot be carried on except for a loss in future, then the court will order its dissolution. So you will write down this point belongs to dissolution of firm order by court under section 44, clause F, where there is a continuous and perpetual losses. So where the business cannot be carried on, only it can be carried on for losses in future, then the court will order the dissolution of the firm. You cannot do the business just for losses. You cannot waste time in the world's economy by just sitting and opening a business for earning losses. So that is that is not allowed. So court will order the dissolution. Is that clear? Point number F. And point number G is very, very interesting. Just an equitable grounds. Just an equitable means कोर्ट को ऐसा लगता है कि आपकी फर्म को बंद कर देना चाहिए. Where court finds it's just and equitable means correct. Equitable means at the right of equity. Equitable for everyone. And just means fair. When does the court finds that the four cases in which the court will want you to wind up your firm? Number one, deadlock in the management. Deadlock in the management means A is saying, I want to run the management this way, B is saying, I want to do it this way, C is saying, so there's a deadlock. Nobody knows how the management needs to be run. When the partners are not in talking terms, one partner is sitting with a face like this, another is sitting with a face like this, they don't want to look at each other, they're always fighting, they're always quarreling, they're always having a fight in the office. Court will say, better you dissolve the firm. You should do a sole proprietorship, don't do partnership there. If you have that kind of aggressive nature that you can't cooperate with anyone, better you dissolve the firm. Loss of substantrum. Loss of substantrum means loss of trust and faith. Like I told you that 1 crore he has put up in his pocket. That means he has cheated with the firm. You have lost your trust and faith on him. You cannot do business with him. So better you wind up the firm. Gambling by a partner on stock exchange. Beta, एक होता है trading on stock exchange. You're investing your money on mutual funds and you're making money. One is gambling. If you're into such kind of illegal activities, then the firm will be getting dissolved by the court's order. So this is how beautifully the chart has been made. Section 40 to 43, mutual agreement, compulsory dissolution. 41, remember that case when the partnership becomes unlawful. Happening of certain event. 42 में वो 4 cases है, fixed partnership, particular partnership, death of the partner, insolvency. And notice किसके case में 43 में when the partnership is at will. Section 44, 7 cases we have discussed. Okay, now we are going to wind up the section 45 to 55. 10 small sections are left, which are very, very simple and easy for you. So I give you 2 minutes. Just go through all the points that we have done right now, and then we are going to wind up the syllabus and also certain MCQs. Let's take a small break here. I hope no doubts till section 44 now. If you still have any doubts, you can raise your hands. All right. Consequences of dissolution. Now we have done the modes of dissolution, how the dissolution happens. Now we are going to discuss in detail about what will happen if the firm is dissolved. So I'm going to ask you a question that there are three partners, A, B, and C, and they were agreeing to share the profits in 2:1:1 ratio. Now they're dissolving the firm. What will be the consequence? What are the implications once the firm is dissolving? What were their rights and liabilities? Do you think that 2:1:1 is the profit sharing ratio, and whatever is left in the partnership, they will divide the profits among themselves? Or they need to do something else? They need to pay to the outsiders also. What do you think will happen? Just apply your mind in general and tell me. You all have to answer me back. Absolutely correct, ma'am. They all will first pay off the liabilities of the outsiders, and whatever is left will be divided among the partners. Okay? Absolutely correct. So liabilities, now what are the liabilities? First, third parties are to be paid, then capital, then profits. Absolutely correct. Anushka, Pavan, Divyansh, सबने सही आंसर दिया है. Anish has written a query also. Anish K. Okay, I'll read your queries. Can you explain these lines? Adjudication of all the partners. Okay. Vanisha, adjudication of all the partners as insolvent means if all the partners or one of the partner is declared insolvent. Adjudicate करना means declare कर देना उसको insolvent. Insolvent कब declare होते हैं? When you don't have much of the assets to pay off your liabilities. Anish K has written if ABS are partners and they want to dissolve since the firm has incurred losses from 3 years and also in the future they are not going the case if it is unregistered firm. He's asking if it is dissolution, if it was unregistered firm. Why are you linking the dissolution with the registration of the firm? Firm can be dissolved whether you are a registered or unregistered firm. Dissolve का मतलब होता है firm को end करना. So if you are into continuous losses, you have to dissolve the firm. That will be as per section 44 clause F. Okay? Clear? All right. So all the queries are also answered. Now liability for the acts done after dissolution. Now you all have correctly answered that what will be the liability, ma'am? First we'll pay to the outsiders and then we will take the profits home. But what about the acts done after dissolution? Notwithstanding the dissolution means if dissolution of the firm has happened and partners still hold liability towards the third parties, then what would be the case? Until the public notice is given for the dissolution, they will remain liable to the third parties. So you dissolve the firm on 1st August and still there was a loan which repayment has to be made in 5th August. You have to repay that loan of 5th August. You cannot say that we have dissolved the firm, now will not pay your loan. Until the date public notice means if you have further done any transactions and you have not given the public notice, you continue to remain liable to the outsiders. Estate of a partner who dies or has become insolvent or a partner not having known to the partners means he's a sleeping partner, he retires, then he is not required to give the public notice. Okay? So section 45 has two objectives. One is the parties dealing with the firms who had no notice of prior dissolution and protection is given from the liability of third parties is those that are sleeping partners, dormant partners, and partner who has died or insolvent. They are not required to give public notice. But other than those, no notice has been given. They continue to remain liable to the third parties. X and Y carries on the business for several years, executed on 1st December a deed dissolving the partnership from the date but failed to give the public notice. 1st December को उन्होंने बंद कर दिया business, but they have not given the public notice. On 20th December, X borrowed in the firm's name a sum of money from R. Y will also be liable because no public notice was given. Can anyone explain me this last line? Y will also be liable. X has borrowed the money. Why are you making Y liable? It says Y is also liable. Please tell me, class, why have we held Y liable for this transaction? X has borrowed the money. I want everyone to give me correct answer. Anushka, Anil, Anish, absolutely correct, all of you. Because of mutual agency and no public notice has been given. Altamas, Divyansh, Prapreet, Suraj, all of you, Miss Kaushal, good, correct answers have to be given. Yes. So mutual agency is there. So all the partners, because public notice was not given, and on the basis of mutual agency, both the partners will be held liable. Very good, Abdul, Ansupa, absolutely correct. There's certain exceptions to this rule. Even when notice of dissolution has not been given, there is no liability in case of the deceased partner, insolvent and dominant partner, because he's not known to the outsiders. Okay? Right of the partners to have business wound up after dissolution. So section 46 tells you that all the business shall be closed, outsiders will be paid off, payment of the debts and liabilities will be done, and if there is any surplus, shall be divided among the partners or their legal representatives, whatever is the case. Continuing authority of the partners for the winding up, whatever obligations they are required to do till the winding up process, they should continue with their rights and duties. It may be necessary to wind the affairs and to complete the transactions again, but unfinished at the time of dissolution. It says, for example, we have started certain work. There was an assignment going on, 50 bags of wheat to be given, and we are in a partnership. After 30 bags of wheat has been given, and we decided to dissolve the firm, but those 20 remaining bags still have to be delivered. Your rights and obligations for completing the task still remain, even if you are winding up the firm. In no case, partners are bound by the acts of the partner who has become insolvent. Insolvency and death of the partner will not affect him. Okay. Now, last section 48 and 49 are very, very simple. They tell you how the partnership accounts needs to be settled off. Settlement of partnership accounts, which is your favorite part in accounts chapter also. It tells you if there are losses in the firm, including deficiencies of capital. So 10,000, 10,000, 10,000, all of us have contributed the capital, and now we are into 50,000 losses. So first, deficiencies of capital, 30,000 need to be paid out of the profits. First, you will pay whatever previous profits. Suppose 1 lakh for the previous profits, you will pay the liabilities out of that. Then you will use this 30,000 capital to be paying off the liabilities. And if necessary, means if still liabilities need to be paid, partners will have to, personal assets have to be brought in from their home individually. In what ratio? In 2:1:1 ratio. Which ratio will be sharing the profits? In the same ratio, we need to pay off our liabilities also. Is that clear? This was about the losses, how you have to pay. First out of the profits. Please write down losses will be paid first out of profits, then out of capital, and then personally partners have to pay. How the assets of the firm are to be used? Assets will also be used first to pay the liabilities of the outsiders, then to pay the partners for their capital, then paying the partners for any kind of advance that has been given by them. And then if any balance is left, will be divided among the partners. Residue means the balance that is left will be divided among the partners in their profit sharing ratio. So X and Y are partners sharing the profits equally, and X died. It transpired that he contributed 6,60,000 to the capital, and Y has only bought in 40,000 capital. Now the assets were worth rupees 2 lakh. In that situation, if 6,60,000 is the contribution capital and 40,000, then out of whole of the amounts, that is 7 lakhs and 2 lakh is the assets. So this is the capital plus the assets, at 5 lakh have to be equally shared among both of them. You cannot say that I just bought this much capital only, and or Mr. X cannot say that I bought so much capital, you're just giving me 2,50,000 my share. No. You have to equally share because you were equal profits. Now, whatever capital you have brought, whatever business you have done, accordingly, you will get the share of profits. It says surplus assets have to be shared irrespective of their interest in the capital, and dissolution of the firm or deficiency of capital was found. Then the assets will be divided in proportion to the capital, with results X's estate would have the main loser. X's estate is main loser because he has contributed large amount of capital. वाई ने तो कम करे, तो आपको डिसाइड करना है भी आपको कैपिटल रेशियो में रखना है, प्रॉफिट शेयरिंग रेशियो में, एंड देन यू हैव टू follow whatever ratio you have decided. And last section 49 tells you how the joint debts have to be paid. Now listen very, very carefully. Section 49 is little tricky. But first tell me section 48, everyone clear? 45, 46, 47, 48. All these sections are clear. Quickly reply me in the chat box, children. Everyone is clear about these sections? Any doubts? Okay, wonderful. All clear, ma'am. Absolutely clear is the most wonderful line that I enjoy listening from my students, which boost my courage and efforts also to keep you highly motivated and move forward. All right, thank you. I'm glad you have understood it nicely. So now section 49, the last section of this chapter, payment of firm's debts and payment of separate debts. Firm's debts means जो firm का पैसा हमने देना है liability to the third parties outsiders. Separate debts means if I am a partner in your firm and I might have taken certain amount of loan from outsiders and now I also need to pay back that. So sometimes there are joint debts due from the firm and separate debts due from the partner. Then section 49 needs to be applied. It says whatever is the property of the firm, like the table, furniture, lights, everything, house, the office, place, everything which is the joint property of the partners, that property of the firm will be first used for paying the debts of the firm. And if any surplus is left, then the share of the profits shall be used for paying the separate debts of that partner. Then share of each of the partner will be used for paying the separate debts of the partner. So say for example, 40,000 amount has been left as the property of the firm and there was liability of 30,000 which was firm's liability. So that 40,000 will first be used for paying the 30,000 liability. And suppose one of the partner has taken a loan of 5,000, then balance 10,000 may say 5,000 you can use to pay off the separate debts of the partner. But this Mr. B who has taken a separate debt from any of the partner, a separate debt was due. He has borrowed 5,000 rupees from Mr. D and he has contributed a laptop in the partnership. So that is his separate property. Now that separate property of the partner will first use for paying the separate debt, that is 5,000. And if anything is still left from that laptop, that will be used in payment of the debts of the firm. So what do we have to remember in section 49? Joint liability, joint property of the firm, pay that liability. If anything is left, pay the separate debt of the partner. Separate property of the partner used to pay the separate debts of the partner. If anything is left, pay the debts of the firm. Is that clear? Why do firm pay partners' personal debt? So Pavan Kumar, sometime a partner is owing certain amount. They have taken it in the name of partnership firm only, but that amount is respectively due from a partner. So again, partnership is on the basis of your mutual trust and confidence. You have contributed equally. So you have to understand on the basis of the same theory that sometimes the separate debts are also due from any of the partner. You have taken a certain amount of loan for the business purpose only. So now the business is winding up, dissolving. You cannot just say that all the assets of the firm shall be first used to pay my dues because I took it for the partnership firm. No. If the all joint assets of the firm, first you will be paying the joint liabilities of the partnership. If anything is left, then yes, you can pay your separate debts also. Okay? Is that clear, everyone? He might have given certain money to the partnership firm only. That can also be a debt due from any partner. कुछ उधार दिया हो, ठीक है? So this we come to an end of dissolution and registration. So yeah, Indian Partnership Act 1932 has ended, children. Go through all these MCQ questions. And you should study the descriptive questions. See, straight away questions have come up. Indian Partnership does not make the registration compulsory, nor does it impose any penalty. So what will you write over here? Section 69, all the 4 points along with the 5 exceptions given, you have to write it. Dissolution of partnership take place. How does it take place? Section 40 to 44, all the points. What is the procedure for registration? Section 58, 59, 59A, 1 penalty. All the points have to be written. So if you try writing down them and practicing, your whole of the chapter notes will become and whole of the chapter will get revised. See how beautifully they have given you the answers also. So with this, we come to an end of Indian Partnership Act 1932 lectures. I hope you have revised doing these chapters with me, children. And still, if you have any doubts, feel free to raise your hands and ask me. I'm here for 2 more minutes. If you want to ask your doubts, you can please ask your doubts. Feel free to ask your doubts, children. Any query you have, anything you want to understand, anything you have a doubt in your mind related to Indian partnership, you can ask me. Okay, Gauri wants to speak something. Yes, Gauri.
Study models questions enough for examination, ma'am?
Study in itself is sufficient for examination preparation, but for practice, you should do all those questions along with all the MTPs, RTPs, and the previous year question papers should be done. So you have to test your knowledge by seeing all those question papers, what kind of questions are coming in exam. Study while descriptive is good enough for practicing.
Thank you, ma'am.
All right. Yes, Akshit.
Ma'am, after revising this chapter, what we have to do after practicing these questions for reference, what we have to do, ma'am?
So you can refer to your study material as well as my notes. That is sufficient for your preparation.
Ma'am, dissolution, the 7th point, can you explain, ma'am? Dissolution and difference between.
7th point of difference between dissolution?
Yes, ma'am.
Okay, I'll just take you there. What have you not understood over there?
The tabular column, I did not understand the what is being said or the difference between, ma'am.
Okay, I'll just open it. There are 5 points of differences. Which point you have not understood?
No, ma'am, this one not, ma'am. That difference between another that slide. Not this one. That difference between 7 points was there. Another slide, not book one, not, ma'am. Another one slide. So you shown, no, ma'am.
In my presentation?
Yes, ma'am.
Okay, I'll open my presentation. I think I also have 5 points because I've taken it from the module itself. Yes. Yes, which one you have not understood?
This one, first one and 7th one alone, ma'am.
7, there are 5 points, child. They're not 7 points. So the
First
first
one
point, okay, I'll explain you the first point. First point tells you, first of all, the exact meaning of dissolution of firm and dissolution of partnership. When we talk about dissolution of firm, means entire firm is getting closed. Discontinuance of business means हमारा business बंद हो रहा है. Whatever we have been doing in partnership, now we are doing a complete closure of that. But dissolution of partnership only means that the partnership between us has ended. Either it has got extended by adding a new partner, or it has got reduced by reducing a partner. So business has not ended, only the partnership has changed. In dissolution of firm, the whole business comes to an end. Okay? Clear, Akshat?
Yes, ma'am.
Alright.
Then final closure means what, ma'am?
Final closure means you are closing the books of accounts, means now you are entering everything, no entry will be made anymore. The books are closed. Now you're not doing any more business in that. So firm is dissolved, means completely finished. Band kar diya aapne business. Books ko band kar dena means you're not going to do any entry in that. But in partnership, you're not closing the books of accounts. So somebody is just joining the firm. They're becoming an add-ons or the partners are getting reduced. Okay, there you're not closing the business.
Ma'am, for today, next class, I saw the schedule only accounting is there, means daily accounting only.
I'll be meeting you for Companies Act soon. All right?
Company. Ma'am,
Yeah.
we'll be meeting after how many days, ma'am?
You'll get to know through the schedule, beta. Okay,
Oh.
Abdul has a query. He has written something in the chat box. Let me just take up his question. Example number 6, where it is mentioned the amount of debts to be paid off by X and Y. So I'll take you to example number 6. Abdul, what have you not understood in example number 6, child? Example 6 we have just done. What is your query for example number 6? Thank you, Priyanshi Nagar. I'm glad you've enjoyed the session. amount of debts to be paid off by X and Y. So, Abdul, they're just trying to tell you, they're just giving you an example in this, that even if I've given a higher amount of capital, the other has given a lower amount of capital, whatever will be the balance, if we have decided to share it among the profit ratio, then X will be at loss. They are not telling you what debts have to be paid. It is just an example to explain you how the capitals can also be in different proportion. All right. Understood? Liquidated damages meaning. Preet, liquidated damages is part of your Indian Contract Act. Still, if you have asked me, there is a difference between liquidated damages and penalty. So liquidated damages is the prefixed amount that is mentioned in your contract itself, and penalty is something which is imposed additional. Okay. Akshat is saying, ma'am, section 49 in simple words. Simple words, you want me to explain it in Hindi? Are you trying to say that? So explain you in simple words only, Akshat. So if you want me to tell you in Hindi, I can tell you that section 49 simply tells you कई बार firm के debts भी होते हैं and personal debts भी होते हैं partners के. तो जो firm की property है वो पहले firm के debts means firm की liabilities pay करने के लिए use करेंगे. If balance is there, तो separate partner का debt पे होगा. जो partner की separate property है, जैसे कि हमने example लिया था partner का laptop है, तो उस लैपटॉप में से जो हम रियलाइज करेंगे सेल करके पैसा आएगा, वो पहले पार्टनर के सेपरेट डेट्स पे करेंगे, फिर फर्म के डेट्स पे करेंगे. Okay, so that is what is section 49. So all the best, students. Gauri, I hope you have asked your doubt. There is no more doubts.
No, ma'am.
All right. Yes, Divyansh, absolutely correct. It is similar to that. All right. Thank you so much, children. I hope you have enjoyed the session and you have understood everything that we have discussed. Revise your Indian Partnership Act very well, and I see you for the Companies Act soon. All the best. God bless you all.